And that's Taylor Zion?
That's mine.
Okay, just give me one moment, council, and I'll take up Shannon Anderson, and then I'll take up Zion.
Justin Twillies.
Yes, ma'am.
Okay.
I will make sure it's done. Thank you. Yes, ma'am.
All right, Shannon Anderson. And council, is this an application? All right, probation, this is an application. All right, court is calling 2023 CR 9710 State versus Shannon Anderson. For the state
Andrew Harrison.
defense.
Mark.
And are you Mr. Anderson?
Yes, ma'am.
Counsel, have you reviewed all of the discovery with your client?
Yes, sir.
And have you received all discovery?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Anderson, did you review the application for deferred adjudication with your attorney? Did
Yes,
you
ma'am.
understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? It appears that you're proceeding on count two.
Count two, leaving count one and proceeding on count two.
Any objection?
No objections.
Mr. Anderson, did you review the admonishments with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right. Did you understand in count two, you're charged with the offense of robbery? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you enter a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I-
Mr. Anderson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count two. There's a $2,000 fine. State recommends deferred adjudication, and there's to be no contact with the complainant. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 10 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with the complainant. Did you understand?
Yes, ma'am.
Did you understand that those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense of, as charged in count 2, how do you plead?
No
Guilty?
contest.
State any evidence?
No objections.
Are you okay? Yeah. All right. State, have you spoken with the complainant?
I don't know, Judge.
Okay.
EDA Garahan crafted this agreement. There may be notes in Odyssey. If Mr. Garahan has spoken with the complainant personally, I'm not aware at this stage.
All right, thank you. And Mr. Edelman, if you'll give that to probation, because she's going to need to know the name of the complainant.
Yes, Judge.
All right, did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you, for your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same, and state you may be excused.
Thank you.
After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client?
Your Honor, he has accepted responsibility. Well, more than anything else, he's motivated by his desire to be there for his children, his 2 small kids. That's something that's been brought up pretty much every single time we come to court.
All right, how old are your children?
My daughter is 15, and my son is 14.
All right, so they were currently alive when this incident occurred. So why were you not thinking about them at that time?
No explanation.
All right, people always think about their children, I've discovered, when they have a criminal case or there is something else going on in their lives. And usually they're using their children as a prop to say, please don't send me to prison. I have children, or know that I am going to do things differently because I have children, as though they haven't had children before. So do your children stay with you?
Yes.
How far did you go in school?
I graduated with 2 years JUCO,
Okay. And so JUCO?
junior college.
All right, so why don't people say the words juvenile, junior college? I'm sorry, what?
Melody.
See, that's the problem with young people today. They're abbreviating everything.
I think also has to do with, because you were playing football.
Correct.
And again, in the sports arena, they often refer to that as bingo.
All right, so you played football
In seventh grade, Your Honor.
and you just decided to give up your dream.
I peaked in seventh grade. It was downhill after that.
You could have been a linebacker or something.
I was Rudy before there was Rudy.
So what do you do for a living?
I run a power washing company.
All right. Court will sentence you to 10 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home healthcare provider or with minors, $2,000 fine. That will be probated. There's to be no contact and restitution to the complainant. Counsel, if you feel that the restitution amount is not appropriate, we can have a restitution hearing. Field visits 1 time per month for 6 months. If you're drug tested today, what are the results going to be?
Positive.
See, you're not setting a good example for your children. You're not allowed to use marijuana or drink alcohol while you're on probation. Do you understand?
Yes,
It's going to be 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. With the UAs, test for levels. How often are you using marijuana?
as of now, not anymore, but every day.
All right. So we're going to do a TAP evaluation out of custody. And you need to be honest with probation on the amount you've been using.
Mhm.
That's yes or no.
Oh, yes, ma'am.
All right. And then probation, if they recommend inpatient treatment, we'll start with intensive outpatient treatment. And I'm going to want 60 sober meetings in 60 days. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes,
All right, good luck to you. Do better.
yes, ma'am.
All right, thank you.
Thank you, Judge.
You're welcome.
Appreciate it.
State, do you have an ETA on your fingerprint examiner? Okay,
It's not really an ETA, Judge.
no.
It's sort of a general approximation.
Vashawn, that's like when people ask you, are you on your way? And you're always parking, right?
So I asked you yesterday, Judge, are you on your way? Are you still at work?
You put Corliss Johnson.
Oh, it's up here.
Oh, you have it already,
Yes.
Judge?
I'll call. Just give me a moment. And they have to
That's a
bring,
bad sign, I think.
no, they just have to bring, make sure you let the deputy know.
She was here earlier. She was here. Yeah. She was here. Castro, did it already go to that?
No.
Oh.
He hasn't came, he's on the Zoom meeting. So he
Oh,
hasn't
okay,
came.
thank you.
Your Honor, may I approach?
Just give me one moment.
Yes, Judge. Flores?
All right, you wanted to approach?
Oh, yes, Your Honor. David Castro. Is that-
Castro, is that the red hearing?
Abby's here.
Andrews? Do y'all have witnesses?
My folder fell. Papers escaped.
Mhm.
I can just figure out the escapes.
All right, so this is what's gonna end up happening. We have an expert who's coming over to fingerprint. And then I'm gonna have a hearing on whether or not I will allow that to occur. It appears, defense, it appears that you have notice because of the way the indictment is charged. He's charged as a habitual. But I'm gonna hear everybody's motions and hear what argument you have as it relates to the fingerprinting. And then you all say you have one witness, but is this gonna last long?
I don't, oh, sorry, I don't know.
30 to 40 minutes.
Okay, so 30 to 40 minutes, Judge Nahara is gonna have to hear your motion.
So that's good.
And Your Honor, if I can just confer with defense for just a minute.
Sure.
Is there?
All right, who's here on Zion? Hello. All right, have you conferred with the state?
I have, Judge. They've made him an offer and he has declined the offer, Judge.
All right, how long do y'all expect this jury trial to last?
I would say,
2 days?
I'd say 3.
All right, Norma. I need a jury trial date. It's criminal trial division, 2 days. Mhm.
That works.
July 8th.
All right, July 8th. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you're gonna have to plead open to the court. Do you understand?
Yes, ma'am.
All right, once you sign the reset form, you're excused.
Thank you, Judge.
You're welcome. And to everybody else, we're just waiting for the inmates to come up. Christina, who is Christina Martinez? Who's on that? And Dominique Nicholson. David Castro. All right, so that's the one that's gonna go to Judge Nahara, and I'll send him an email. I think the state wanted to speak to you briefly.
Andrew, you
Yes.
passed that on bond, right?
Yes.
Yes.
Oh, that's okay.
And I'll write off the other one for you.
All right, thank you so much. That is so true. Thank you. All right, and Norma, this needs to go down with them. It's the bond motion. And what is the cause number on that? So I can send an email to Judge Nahara? No, it's a CM. Yes.
20070.
All right, thank you. And Mr. Wheat, we're just waiting for your person to be brought out.
I mean, the state will be here. So.
I know, but I'd like for clients to be here.
Yeah, I was looking at your. Oh. Yes. Oh, I was thinking you might have here in the box already. And she can be trying.
Please, you follow motion to move on to public hearing, this will approve it, and choose the-
She was here. She was here. Oh, we don't.
So you're not.
Well, I wanted to go back to that. You want to, like.
Oh, please be seated.
Robert.
This is for your sign, and if you can give two to the state, and if you'll give this to the, is that two or is that one?
I'm gonna have my client going.
All right, yeah.
I got three right here.
All right, and then one for the
And this is,
court reporter.
this is Katie.
That's going to.
And again, I did it without putting the page numbers on it. All right, so has the fingerprint where is the fingerprint person?
That's a fantastic question.
I mean, are they on their way as far as they're still at their house? Or are they en route? What does that mean?
Judge, I will tell you, my trial last week took them 2.5 hours to get here.
Okay. So Judge Nahara is able to take those two, so yes.
Is it, are they pleased, Judge?
No, it's just for them to have their bond hearing.
Oh, okay.
So what?
Andrew, taking his client down?
Yes.
Yeah, was downstairs. She was just one. She's like, nobody's here.
Oh, no, they're on their way down, and I just received an email from Judge Nahara who said he will take it.
Here, Judge.
All right, so can you bring him out? All right, are you all ready? Okay. All right, if you'll have your client come down, please. Hello. Hello. Hi. All right. On this case, is there, I'm sorry, what?
You want to come back next week?
Okay. So, yeah, next week
Okay,
is not available.
Then, I mean, the week after, there's a bunch of different things we need to discuss about her possible rehabilitation. And we just can't do it today, and I wish we could.
Okay. And she has a motion to revoke pending, correct?
She does.
All right. Ms. Abrams,
That's good.
on this case, it's a motion to revoke. Is this going to be contested?
I don't expect it to be, Judge.
All right. If it turns out to be contested, do you have any objection to the probation officer appearing by Zoom?
No.
All right, Norma, if you'll set this for contested the week of March 17th. March 17th, is that good for you, counsel?
Double check.
And if it turns out that it's not a contested, then it won't be a contested.
Okay. I like the way you said that. If it turns out it's not contested.
Then it won't be
it's not
contested.
Contested.
There we
It's
go.
just simple.
Yes. I find that if you keep it simple, people will understand.
March 17th, 9 a.m.
Yes.
Okay.
All right, we'll see you all back on the 17th.
Thank you, Judge.
You're welcome.
Have a seat then.
Yeah, just thanks.
And on that one, Ms. Abrams, if it's contested, they can appear by Zoom. All right, who else is in the box? All right. Who's your client?
Lawrence?
Come down.
Definitely, ma'am.
All right, did you confer with the state?
Yes, sir.
All right, court is calling 2023 CR 9341 State of Texas versus Courtney Flores, AKA Courtney Sloan. Could I have parties announced for the record for the state?
Kim Galloway for the state.
Defense?
Valentina Coco on behalf of defense.
Are you Courtney Sloan?
Yes, ma'am.
All right, the defense has requested that a bond be set. It's the court's understanding that you all have reached an agreement in the amount of $10,000 with previous bond conditions. All right, the reason why you don't have a bond is because on January 28th, you failed to appear. Why was your client not present?
She had a lot going on in her life.
You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, so in order for me to set a bond that's appropriate, I have to know that you're going to appear for court. That's one of the main things about bond. Isn't an amount where somebody is saying the cost of not appearing outweighs not appearing. Do you understand?
Yes, ma'am.
So why were you not here?
My brother passed away on January 15th.
I'm sorry to hear about that. Next time, here's the thing, all you have to do is pick up the phone. If you would have picked up the phone, the state will tell you, your attorney will tell you, if you would have picked up the phone and called the court and said, my brother passed, may I have a reset, or let your attorney know, then guess what would have ended up happening? The case would have been reset. You understand?
Yes, ma'am.
All right, is there anything else?
Not from the defense here.
All right, I'm going to follow your agreement. Set the bond at $10,000. Who is the alleged complainant? All right. There's going to be no contact with the complainant. Oh, just 1 second. I'm sorry. It should be in the indictment. All right, it's Dollar General. So you're not to have any contact with Dollar General stores. You understand?
Yes, ma'am.
Counsel, have you received discovery in this case?
You and I need to double check whether or not I've received everything.
All right, Norma.
It's the right check on March 20th.
All right, so give her a reset form for March 24th. All right, thank you.
Thank you.
Have yours.
Thank you.
You're welcome. All right, who's the other person over there in custody?
We have Christina Martinez and Luis Martinez.
Judge, that's but the Gower's client is Ms. Martinez, so we reset that one to page 2016 trial.
All right, Mr. Martinez, your attorney is currently in jury trial, so your case is being recalled for March 20th, okay? And we'll bring you back. Thank you. And Deputy Mejia, the rest can go. What is your name, miss? All right, who is the attorney for Christina Martinez?
1 second.
James Sullivan.
All right, we're gonna bring you back on March 17th, okay? All right, so you can empty the box.
Okay, let's go.
Go ahead. Johnson,
Yeah, Nicholas, yeah, he's been on housing.
he's the one for the motion from the trial. For read from the client.
Recall that for March 17th.
I think he told, no, it's first for the 24.
All right, no, because that one, that's on time constraints.
Okay.
Yes,
17th.
yes. It's Juan Rogelio Lozano.
He's the one that's they're waiting for that treatment. That's it.
We, he said that's
April 8th.
April.
Now we're gonna
The
call
week
it.
after, the 14th.
April 14th. Yeah, I have it.
Yeah.
All right. All right, do y'all have a copy of the motion for the fingerprint? If somebody could tender that to me. In 2023 CR 9068, State versus Jose Roberto Lopez. Can I have parties announced for the record? State.
Megan Galloway and Andrew Edelman for the state.
Eric Chirek. Robert Porter. For the
And-
defendants.
And are you Mr. Lopez?
Yes.
All right, so the state filed a motion today to require the defendant to be fingerprinted. And it is the court's understanding, defense, that you had objections to that.
Yes, Judge, we believe it was not timely filed. I mean, the rules are clear that pre-trial motions, which we would consider that have to be filed before trial. And the defense has, I believe, 10 days notice before any hearing on it.
All right, state your response.
A long list of cases from the Court of Criminal Appeals holds that it is proper to take the defendant's fingerprints at any stage of the trial. Just citing one, Gordon v. State from the Court of Criminal Appeals from 1971. Appellant complains of having his fingerprints taken during the penalty phase stage of the trial and contends that when the same were introduced and utilized by a fingerprint expert in connection with a prison record to show his prior criminal record, his self-incrimination privilege under Article 1, Section 10 of the Texas Constitution was violated. We do not agree. The court then proceeds to cite T v. State, Branch v. State.
All right, thank you.
Harrington.
But Judge, in response, that applies to the defendant objecting to have his fingerprints printed, not the filing of the motion to take his fingerprints in the middle of a trial.
Is that correct, state?
One moment, Your Honor. Under Cassell v. State Court of Criminal Appeals from 1974, permitting the state to introduce defendant's fingerprints taken during trial without order of court and without presence of counsel did not violate defendant's privilege against self-incrimination.
All right.
Yeah, that's not, that doesn't go to timeliness.
Yeah,
Judge, and it's our understanding that regarding a motion to file, or like the motion to fingerprint, it is able to be filed at any time before punishment begins, and so we did do that in the interim.
And Judge, I want to emphasize something that maybe defense counsel is overlooking. In Cassell v. State, permitting state to introduce defendant's fingerprints taken during trial without order of court did not violate the defendant's self-incrimination privilege. So according to the Court of Criminal Appeals, and for a long, long time, defendant's fingerprints may be taken with or without a motion. And that does not violate the defendant's privileges.
Yeah, and Judge, I would just like to add, I mean, they had noticed that we were seeking to prove up that the defendant was a habitual offender under the indictment, where they were provided the cause numbers to those prior convictions.
All right, the court will grant the state's motion to fingerprint the defendant. Is there anything else from either side?
Judge, on the charge, I believe the elements of the aggravated robbery and the aggravated assault with a deadly weapon coincide. They're the same elements. I believe the state has to make an election as to which one they want to go on punishment.
I don't believe that's true, because count one is regarding the deadly weapon. It has a different element, the added element of theft, and count two is regarding the assault and serious bodily injury.
But we're dealing with the same thing. If you look at it, the first count talks bodily injury, assault, weapon. Count two, weapon, bodily injury, assault.
All right, that will be denied. Are both parties ready to proceed?
Yes, Judge, we have our expert here, but he just needs to take the defendant's fingerprints.
All right, I thought that had been done. All right.
Oh, Judge, I'm sorry. And that's my fault. I thought you wanted to rule on the motion.
No.
I'm sorry.
All right, take the fingerprints, please. While he's taking the fingerprints, could you all review the charge?
Yes,
And
Judge.
see if there are any objections.
Just standing on the objection that the state needs to make an election and the court has ruled on it.
Thank you.
That decides if that big impact is gonna be able to say, hey, you make the decision.
That's who's right here.
Yeah, we're gonna try to introduce that. Not the original file. He still has to match the stuff, got the signature, same person.
Here's your fingerprints on the judgments, in the prior cases with your fingerprints today. It's basically gonna testify whether it's the same or not.
Do I have to do all these?
Yeah.
Robert.
Unless you look it up for that stipulated judgment. That's your options. All right.
Yeah, I'm already getting fucked over.
That's what happens.
And
when
I'm
you
sorry,
go to
Norma,
trial.
what date did we put on Christina Martinez?
Good.
All right. All right, thank you. All right, Mr. Lopez? Are you planning on pleading true to the allegations in the motion as far as your prior history? If not, then he needs to take your fingerprints. So do you wish to plead true to the enhancement allegations? That's either yes or no. And State Defense, do y'all have any objection to the charge of the court on punishment?
Us?
Yes.
Yeah, Judge, I already announced it. We.
So those are the only objections?
Yeah, the only objection. Yes, ma'am.
All right.
State has an objection, Your Honor.
Okay, so then what's going to end up happening is we're going to, once all of the evidence is presented at this phase, we'll move into closing arguments. How much time are you all asking for? 10 minutes?
I think that should be. Yeah.
All right, 10 minutes. All right, with regards to the charge of the court on punishment, defense, your only objection was?
The fact that I believe the state needs to make an election as to what count they want to proceed on punishment because the elements are the same in both accounts.
All right, and State, what is your response?
Our response is that the elements are not the same regarding count one. It has the additional elements of theft, and the allegation is that the offense is committed with a deadly weapon, and count two is just assault causing SBI. And so we don't believe that we need to elect because of those differences in the language.
All right, then defense, your request will be denied.
Judge, then we may have an issue. Let me look at the charge real quick. Yeah, the deadly weapon allegation goes to count two of the indictment. So if they're saying there's no deadly weapon count two, there's a problem.
All right, sir, you can remain seated,
Oh,
Carrie.
okay. Yes, sir. Yeah.
All right, so what is your issue, counsel?
My issue, Judge, is she's saying that count two doesn't have the same elements because they're saying it's serious bodily
Oh,
injury.
you can have a seat.
Oh, okay. But the deadly weapon finding is directly related to count two.
Yes.
So how, if they're saying serious bodily injury, it's either a deadly weapon or it's not a deadly weapon. Therefore, it's the same as count one.
All right, so I understand your argument, counsel. That will be denied. All right, and State, you say you have 3 witnesses?
Yes, sir.
So I'm assuming that you only need 1 witness we can go off the record. I'm assuming you only need 1 witness with regards to the fingerprints.
I believe so, Judge.
All right, so let's bring in the other witnesses. The jurors are in the back waiting. Yes.
Yeah. Definitely. Imagine it says here.
No. The jurors have been waiting.
Your Honor, I guess I gotta wait till they're in here.
Mhm. And then your client can remain seated when they ask if he pleads true or not true.
Thank you. Your Honor.
All right. All right, let's bring the jurors in.
Judge,
Yes.
I don't know who they intend to call, but if they're new witnesses that haven't seen anything like that, then we're gonna vote the rule at this time. I don't want the other witnesses sitting in.
If it's what?
I don't want the other witnesses sitting in while the fingerprints are going on.
I don't know.
All right.
I don't know who that is.
Hello.
I'm an intern in the district attorney's office.
All right. All right, thank you.
Oh, I thought they said there was 3 witnesses and you told them to bring them all in.
No, no, no.
Oh,
I
okay.
told them to come in.
Oh, okay.
You brought him up there already, Judge?
No, just have a seat. All right, yes.
Don't tell you did.
Right, everyone, please be seated. All right, State, could you read the enhancement allegations, please?
And it is further presented in and to said court that before the commission of the offense alleged above, hereafter styled the primary offense on the 11th of January AD 2006 in cause number 2006 CR 0197W in Bear County, Texas. The defendant was convicted of the felony of burglary, habitation, intent to commit assault. Before the commission of the primary offense and after the conviction in cause number 2006 CR 0197W is final. The defendant committed the felony of aggravated assault with a deadly weapon repeater and was convicted on the 9th day of December AD 2010 in cause number 2009 CR 9963 in Bear County, Texas, against the peace and dignity of the state.
All right, to both of those enhancements, how do you plead, true or not true?
Not true, Your Honor.
All right, State, do you have any opening statements?
Just briefly, Judge. Ladies and gentlemen, we are now in the punishment phase of this trial after you've returned your verdict. And here is where you get to consider what we talked about in jury selection, right? When assessing a punishment against the defendant, we talked about what's most important to you. If he's committed violent offenses before, the effect that it had on the victim and helping the victim to make amends. And so the state is going to prove that the defendant has been convicted of 2 prior felonies, violent felonies, burglary of a habitation, and aggravated assault with a deadly weapon. And also the state has evidence of an assault that the defendant committed against his mother. And we will submit that evidence to you and then ask you for a verdict when we're done with that. Thank you.
All right, defense.
Thank you, Your Honor.
All right, state, you may call your first witness.
The state calls Robert Jimenez.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you may be seated. Just make sure you keep your voice up so members of the jury can hear. State, you may proceed.
Mr. Jimenez, would you please introduce yourself to the jury and let them know what you do for a living?
My name is Robert Jimenez. I'm a records identification supervisor with the Fair County Sheriff's Office. I've been gainfully employed for 32 years with the department, and I also am an expert.
And how long have you been doing fingerprint identification?
Approximately 23 years.
And what are your duties as a records employee with the sheriff's office?
I oversee a department of a shift of about approximately 15 employees that handle clerical as well as identification section, which has to do with fingerprints.
Okay. And can you explain to the jury any training and experience and background that you have in fingerprint identification?
Yes, on May 24th, 1996, I received certification from the Texas Commission on Law Enforcement in basic fingerprint science. The course was 2 weeks long.
And have you testified in court before regarding fingerprint identification?
Yes, many times.
Okay. And can you describe to the jury what a fingerprint is?
Fingerprint are the friction ridges that are taken from the tips of the fingers and put with ink to identify the patterns.
And have you ever found or heard of 2 people having the exact same set of fingerprints?
No, I have not.
Okay. And can you describe what the inked print is?
The ink print is taken at the time that the subject is placed in the custody of the sheriff. What they do is they roll the prints evenly, so that way we get all 10 fingers on the fingerprint card, as well as the slap prints, which are the plain impressions. And from there they send us the information with the card, so that way we can make positive identification and verify the person.
Okay. And so did you take fingerprints from anyone in the courtroom today?
Yes, I do.
Okay, and can you point to who you took their fingerprint?
Yes, putting their.
And can you, thank you. Can you identify him by an article of clothing he's wearing?
Yes, he's wearing black, sure.
Let the record reflect this witness has identified the defendant. Okay, and so I'm going to show you a couple of things. So I'm showing you what's been marked as State's Exhibit P1. Can you tell the jury what that is?
It's P1 They acquired it
And from who is that taken?
from myself.
And of the defendant, is that correct?
That is correct.
Okay, and that was taken here in court.
Yes, it was.
Okay, and that was taken by you.
Yes.
And what kind of prints are those on that?
These are just regular 10 print.
Okay.
Excuse me. Hi. Y'all, if you're having a conversation, it needs to be on the record and it needs to be for everyone to hear.
Okay, so. Judge, let me approach you.
Sure. All right, State, you may continue.
Thank you, Judge. Now I'm showing you what's been marked as P2. Do you recognize this document?
Yes, I do.
And is that document maintained in the normal course of business by the sheriff's office?
Yes, it is.
Okay. Then I'm gonna show you. What's been marked on State Exhibit P3. And have you had a chance to review this document?
Yes, I have.
Okay. Now, looking at State Exhibit P2, can you tell me what that is? P2.
P2 is what we call a booking sheet or booking drop card, which is what we maintain at the sheriff's office. A itemized record of his arrest history, their information.
Okay, and so does it contain unique identifiers on it to identify the defendant?
Yes, yes.
Okay, and are you able to compare the fingerprints that are on the booking sheet and match them to State's Exhibit P1 and then State's Exhibit P3?
Yes.
Okay. Can you go ahead and do that?
Yeah. The two prints that are on the back of the drop card are what we call in and out prints. One is taken at the time he's brought into custody, and the other one is usually taken at the time when he subject for release. And both prints do match prints that I took this afternoon.
Okay, and regarding the booking sheet, State's Exhibit P2, what is the name that is associated with that booking sheet?
The name is Jose Roberto Lopez,
And what is the address that's associated with that defendant?
260 North San Felipe, San Antonio, Texas, 78237.
Okay, and is there a case number that is associated with that booking?
Yes, case number is, it's a ninth magistrate case number. And case number is 855-750.
Okay, and is there a date of offense on that?
Rest.
Okay, and does it say the offense for which the defendant was arrested?
Yes. It's burglary, application, and committed assault.
Can I take a look? Okay, and so what is the booking date that's associated with this booking?
Booking date is October 23rd, 2005.
And what is the SID number that's associated with this defendant?
SID number is 0723-095.
Now I'm gonna show you State's Exhibit P3. You've had a chance to review this, correct?
Yes.
Right, and you compare the fingerprints that are on State's Exhibit P3 to the fingerprints that you took today at State's Exhibit P1.
Yes, I've already made a comparison with fingerprints that were taken today with the fingerprints that are on that photo pack.
And that's State's Exhibit P3?
Yes.
Okay, and have you formed an opinion as to who the prints and State's Exhibit P3 belong to?
Yes, the person whose prints appear on P3 against the prints that I took on State Exhibit P1 are one and the same.
And regarding this, on State's Exhibit P3, can you tell me who's the defendant associated with this judgment? And can you tell me what the date of the offense that was committed?
Date of offense was October 23rd, 2005.
And the offense that was committed?
Burglary, habitation, intent to commit assault.
And what was the case number that's associated with that?
Case number is 2006 CR 0197.
Your Honor, at this time, the state offers State's Exhibits P1, P2, and P3 instead.
Defense, any objection?
Tender to defense.
Judge, I'm gonna object to what number this is.
All right, if parties can approach so the court can view. All right, so the jury is out of the courtroom. So it's the court's understanding that's defense. You have no objection to P1, is that correct?
That is correct, Your Honor.
And you have no objection to P2.
That is correct, Your Honor.
So your objection is to P3.
That is correct, Your
That
Honor.
appears to be a document from the Texas Department of Criminal Justice. And there's a declaration listed by Sarah Wright. All right, what is your objection?
Judge, that under Texas law, they are required
Oh,
to.
please be seated.
Oh, I'm sorry.
It makes
They're
it easier
required to-
for the court reporter to hear.
They're required to file and serve on opposing counsel a business record affidavit at least 14 days before trial. That was not done.
State.
Judge, in our response is that we are offering it under Rule 902. It is evidence that is self-authenticating. It does bear a seal and it's signed and certified by the custodian of records from PDCJ.
I did not see it under seal, and if it's under seal, it's barely not legible.
All right, and the seal is actually on the last page, counsel. Yes.
But it's not signed. Maybe sealed, but it's not signed by the individual.
Well, there's a signature.
No, it's not.
Okay. Okay. All right, any other objection? Sure. Oh, and Mr. Porter, you're more than welcome to make your objections on the record. Okay.
I just want to ask if he wants to.
Sure.
Yeah. Besides the objections. He's making, you also object. As far as. My understanding is the state is offering this to show that.
Yes.
We're going to be objecting to. The number of years of term of agreement, 2 years TC. It's how you file to the judge. To the jury, give them a baseline of what they should or should not do.
All right, so with regards to defense's objection to a P3, that will be overruled. With regards to the amount of time that the defendant received, with regards to the document, the court is going to sustain their objection. It's the court's understanding that the purpose of having the enhancement allegation is just to show that the defendant was convicted of a specific offense. So that will be sustained. The question is, defense, do you have any objection to the state making a copy of P3 and doing the redactions that are requested?
No, I don't, Judge. They'll remove the first page too, which is for this record affidavit.
Well, with removal of the business record affidavit, the court is not going to require them to remove that because that is needed in order for it to be an official document to be presented. But
The first page. Certified says it's a business record affidavit. I didn't give you 45 days notice, and that's my objection. Not 45, 14.
Mhm.
So that's one complete document they've got there. Judge.
yes,
My objection is they didn't serve it on me 14 days.
so you're asking for the removal of page one that shows that it's Sarah Wright?
Actually, I'm objecting to the whole document.
All right, so that objection is going to be overruled.
That's where I'm gonna use.
All right, thank you. So,
Just so I'm clear on what I need to do, it's my understanding that the court would like us to redact out the sentence where it says 2 years.
yes,
And then, well, just to comply with that, if you want to take a look at the last page, I think it contains how much time he actually served in his release date, so I can take that out. if you'd like.
Please.
Yeah.
all right. So then, so
we
the
got
record
that
is
one.
clear,
Sure.
defense.
Yeah, I'll take
You have no objection then to the state making a copy of this. So both parties will know, once they make a copy, then that's not necessarily official in the legal sense of the word. Does everyone understand?
Yes.
And there's no objection to the state then making a copy.
No, there's no objection to the state making a copy, or they can redact that actually too. Just white it out or.
Then you
cross
have
it
no,
out.
then defense, you have no objection to the state making redactions on P3.
No, removing the 2 years.
Don't judge, but may I suggest that that's what would go in front of the jury as rejected,
Yes.
but we'll make that as part of the record for appellate purposes.
Yeah, with the affidavit attached to it.
All right, so that's what I'm saying. You have, both of you are saying two different things.
Yeah,
So, so that the record is clear, there is no objection from the state making a copy of P3. And that copy of P3 with the redactions being submitted to the jury. Is that correct?
that is correct.
All right.
And then the original will be marked as the exhibit for the purpose of appeal.
All right. So if you'll make a copy of that, and if you'll make the copy P3 so that there be no confusion with the jury.
No, leave it on.
Because it says how much time he actually served.
Oh,
You said
okay,
you didn't
yeah,
want
yeah,
that on
yeah,
there.
okay, yeah. I thought that was the affidavit page, I'm sorry.
No. Okay, Judge, and I guess, well, we're intending to offer another one, so I'm anticipating same objections.
All right.
I know.
Tell you what, let's do this. We're off the record. Can I see everyone and can I see P3 and the other document that you all want admitted, please? And if you all will come to the back. All right, let's bring him in. All right, state, you may proceed.
Your Honor, after tendering state exhibits, P1, P2, and P3 to defense, the state offers, P1 through P3 inclusive into evidence.
All right, in my understanding, defense, you have no objections to P1 and P2?
That is correct, Your Honor.
All right, so P1 and P2 are admitted into evidence, and your objections to P3 are noted. Those objections will be overruled, and P3 is admitted into evidence.
And now, Mr. Jimenez, regarding, I'm showing you it's been marked as these exhibits P4 and P5. Have you had a chance to look at this document?
Yes, I have.
And can you explain to the jury what is P4?
Before the copy of a fingerprint card that is kept in the regular course of business here at the Bear County Sheriff's Office.
And was that associated with a booking for an aggravated assault with a deadly weapon?
So
Okay, and can you tell me what is the name associated with P4, the prints on P4?
the name associated is Jose Roberto Lopez.
And what is the SID number?
SID number 723-095.
And what is the date of the,
Date of the prints is October 22nd, 2000.
have you had a chance to look at P4 and compare it to P1?
Yes.
Okay, and do you have an opinion as to who the prints from P4 belong to?
Yes, in comparison, states exhibit P1, states exhibit P4. Their close examination, prints are one and the same. Belong to the same.
Okay, and now I'm showing you P5. And have you had a chance to review the fingerprints that are associated with P5? And have you had a chance to form an opinion as to who the fingerprints belong to in P5?
Fingerprints on P5 belong to Jose Roberto Lopez, as stated in states exhibit P1 and states exhibit P4.
Okay, and then just regarding states exhibit P5, can you tell me what is the cause number associated with that judgment?
Cause number is 2009 CR 9963.
And the defendant's name associated,
Jose Roberto Lopez.
and for what offense?
Offense is aggravated assault with deadly weapon. Motive as repeated.
Your Honor, at this time, the state offers P4 and P5 into evidence, and I'm tendering to defense for inspection.
Judge, as to P5, I would assert the same objection as to the business record affidavit. It was not provided timely.
And is there any objection to P4?
No.
All right, P4 is admitted without objection. If I could see P5, please. All right, the objection to P5 is overruled and P5 is admitted.
We pass the witness, Your Honor.
Any questions?
Yeah. Let me see P5 again. I was up there.
Thank you.
E5 is not under C. We're going to create a search for business record.
All right, could I have parties approach?
Yes.
Okay, would you agree with me that a number of the prints are ineligible? You cannot see the ridges on those? Yes. Pass the witness.
No further questions.
All right, is this witness excused?
By the state, yes, Your Honor.
All right, you may step down. You're welcome. State, call your next witness.
The state calls Rose Hubbs.
You take a seat here, please. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. State.
Ms. Hubbs, will you please introduce yourself to the jury and let them know what you do for a living?
My name is Rosalia Hart. I'm a paralegal in custody of records for San Antonio Police Communication.
Okay, and as a paralegal with the SAPD Communications Division, what are your duties?
I'm responsible for the security, storage, and dissemination of all the records generated by our unit. That includes 911 calls, non-emergency calls, text to 911, and radio transmission.
Okay, and are you a custodian of records for those calls?
Yes,
Okay. Can you explain to the jury how SAPD keeps records of calls that they receive from 911?
we keep a copy of all the calls that we download in our computer. And we upload the copy in evidence.com.
Okay. And when a person calls 911, is there any documentation that's generated as a result of that person calling 911.
Yes, the system generates a call for service or key card.
Okay. Now I want to turn your attention to July 17th of 2023. Do you know if SAPD received any emergency calls that day associated with SAPD case number 23-15-77-25?
Yes,
Okay. And do you know who the call taker was?
or there were more calls.
Okay, well, okay. I am going to show you what's been marked as exhibit B6. Now, do you recognize what this is?
Yes, this is the CD that contains one call related to.
Okay, and have you had an opportunity to review this call?
Yes,
Okay, and is that your identifying mark on State's Exhibit B6?
yes, I initially.
Okay, and that's to certify that you've listened to it, correct?
Yes,
And regarding that specific call, do you know who was the call taker of that call?
yes, her name is Maddie.
Okay, and is State's Exhibit P6 a true and accurate recording of the 911 call that was made on that day?
Yes,
And so you've listened to that recording, is that correct?
yes,
And was the operator competent to operate the device that recorded it on that day?
yes,
Okay. And is that recording an accurate representation of the call that took place on that day?
yes,
To your knowledge, has it been altered in any manner? Okay. And was that recording made at or around the time of the call?
yes.
Your Honor, this, well, I'm tendering to defense for inspection, State's Exhibit E6.
May I take the witness on voir dire, Your Honor?
Yes.
I presume there is a voice on this recording, correct?
Yes,
And there is no way to verify who that person is on the other line, is that correct?
correct.
Judge, I'm gonna object. One, it's hearsay. And two, it's basically a call that cannot be verified. It's not probable in this case.
All right, so with regards to your hearsay objection, that's going to be overruled. And what was your last objection?
That basically, there's no identification of the person who's on the other line.
Is there a legal objection?
It's irrelevant.
All right. Relevancy?
Well, Your Honor, I guess I can wait with the next witness, but I mean, like, if I can have an opportunity to ask her.
All right, you can ask the witness more questions if you want to ask her more questions, but with regards to relevance from the defense, that will be sustained at this time.
And Ms. Hubbs, when SAPD receives calls, is there something generated called an incident and detail report?
Yes,
Okay, and regarding this call, you stated that you've had an opportunity to listen to it. Do you recall who the caller was?
no, and this is not, so there were 5 calls in total, this is not
Okay, hold on just a
the call
second.
for service. The call that's inbound.
Oh,
So each incident number has its own incident detail report, so its own page that will show maybe.
okay. And well, just regarding this call that you listened to, do you recall who the suspect that was associated with the case is?
We'll have to listen. again, but I don't remember.
Okay, I'm sorry. I know you all are seem as though you're having a conversation, but the jury has to hear what you're saying.
Did you want to repeat the question?
Yes.
And so I asked Ms. Hubbs, had she reviewed P6 and if she was able to recall the suspect that this was associated with. P6.
I would have to read this again. I think I know something more.
We'll pass the witness.
Any other questions of this
No
witness?
further questions.
All right, thank you. Is this witness excused or subject for recall?
Well, she's gonna be subject to recall, Your Honor.
All right, if you'll just wait outside, please. State, call your next witness.
The state calls Officer Chapon.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Chacon.
All right, state.
Sir, would you please introduce yourself to the jury and let them know how you're employed?
Good afternoon. My name is Christian Chacon. I'm a patrol officer for the City of San Antonio Police Department.
And how long have you been with SAPD?
I've been with SPD for around 3 years now.
Okay. And what is your current title and assignment with SAPD?
Right now, I'm assigned to the West Patrol B Shift.
And what training and experience did you have to undergo to become a law enforcement officer?
Right now, at that point, I had 8 months of the police academy.
Okay. And what kind of things do they teach you at the police academy?
Clinical, traffic law, tactics, traffic, everything.
And are you a certified peace officer?
Yes, ma'am, I am.
Okay, and were you employed as a police officer with SAPD on July 17th, 2023?
Yes, ma'am, I was.
Do you recall what shift you were working that day?
I was working in West Patrol B Shift.
And were you, or did you generate a report or a call that you responded to on that day?
Yes, ma'am, I generated a supplement.
Okay. Would it help refresh your memory if you had a copy of that?
Yes, ma'am, I have.
Do you have a copy?
Yes, ma'am.
Oh, okay. All right. And can you tell me the SAPD case number associated with that call?
Yes, ma'am. 2315 subsign 25.
Okay. And were you dispatched to 260 North San Felipe Avenue, San Antonio, Texas, 78237?
Yes, ma'am, I was.
Do you recall what type of location that was?
Type of location.
Was it a house, a business, or what?
It was a house.
And was that located in Bear County?
Yes, ma'am, I was.
Okay. And do you recall why you were dispatched there?
Lived in Slaughter Province.
Okay. And upon arrival at the scene, did you make contact with anyone?
Once we made scene, we made contact with family members of the victim.
Okay. And did you eventually make contact with the victim?
Yes, ma'am.
Okay. And what was the victim's name?
Blanca Solis.
Okay. And did you observe any injuries to the victim?
Yes, ma'am. She had some swelling to her face and a bruised lip.
Okay. And were you able to obtain suspect information regarding the assailant?
Yes, we obtained some information regarding the suspect when we meet.
And when you were dispatched there, would that be in response to a 911 call that was received by SAPD?
Yes, ma'am.
Now I'm showing you it's been marked as States Exhibit E7, E8, and P9. Have you had a chance to review those?
Yes,
And are those photos or of the victim that you made contact with on that day at San Felipe?
yes,
Okay. And are those photos a fair and accurate depiction of the injuries that you observed? I'm tendering P7 through P9 inclusive to defense for inspection.
No objection?
All right, P7, P8, and P9 are admitted without objection.
And we pass the witness, Your Honor.
All right, defense.
You just responded to a call to that house, right?
yes, sir.
Was anybody taken into custody?
No, sir.
Do you know if any charges were filed?
We believe we did a injury report. I don't recall exactly what it was.
Okay. So you have no information whether the case went forward with any charges filed or anything like that?
No, sir, I did not need to follow up.
That's the witness.
We have no further questions.
All right, is this witness excused?
Yes, ma'am.
Yes, Judge.
All right, thank you. State, call your next witness.
The state recalls Rose Hub.
All right, you're still under oath, state.
Ms. Hubbs, are you the same Ms. Hubbs that just testified a couple of minutes ago? Okay, and have you had a chance to review State's Exhibit P6?
Yes,
And can you please tell the jury the suspect associated with State's Exhibits P6?
the suspect is Jose Roberto.
Objection, Your Honor, because that is obtained through any hearsay. There's no personal knowledge of who the suspect is in this case.
All right, that will be sustained.
Judge, I mean, it's associated with the call. It's maintained in the normal course of business. So we're offering.
Could I
it.
have parties approach? Step down. Thank you. All right, state, call your next witness.
The state rests. Your-
All right.
Thanks, rest, Your Honor.
State, do you close?
Yes, Your Honor.
Defense, do you
That's
close?
close.
All right, ladies and gentlemen, I'm going to read to you what's entitled Charge of the Court on Punishment. Again, you don't need to memorize this. You will have the original with you. Charge of the Court on Punishment. Members of the jury, by your verdicts returned in this case, you have found the defendant, Jose Lopez, guilty of the offense of aggravated robbery as charged in count 1 of the indictment and guilty of the offense of aggravated assault as charged in count 2 of the indictment. The habitual and offender enhancement allegation paragraphs and the indictment allege that before the commission of the offense alleged in this cause, hereinafter style the primary offense, on the 11th of January 2006, and cause number 2006 CR 0197W in Bexar County, Texas, the defendant was convicted of the felony of burglary of a habitation with intent to commit assault. And before the commission of the primary offense and after conviction, and cause number 2006 CR 0197W was final, the defendant committed the felony of aggravated assault with a deadly weapon repeater and was convicted on the 9th day of December 2010 and cause number 2009 CR 9963 in Bexar County, Texas. To these two enhancement allegation paragraphs, the defendant has pleaded not true. It now becomes your duty under the law to determine whether each of these enhancement allegation is true or not true, and to set the punishment which should be assessed against this defendant. If you find from the evidence beyond a reasonable doubt that both of the enhancement allegation paragraphs set out and the habitual offender enhancement allegation are true, you will so state in your verdict and assess the punishment of the defendant at confinement in the Texas Department of Criminal Justice Institutional Division for life or for any term of not more than 99 years or less than 25 years in each count. If you find from the evidence beyond a reasonable doubt that the defendant has previously been finally convicted of only one felony as alleged in either the first enhancement allegation paragraph or the second enhancement allegation paragraph, you will so state in your verdicts. For count 1, you will assess the punishment of the defendant at confinement in the Texas Department of Criminal Justice Institutional Division for life or for any term of not more than 99 years or less than 15 years. For count 2, you will assess the punishment of the defendant at confinement in the Texas Department of Criminal Justice Institutional Division for life or for any term of not more than 99 years or less than 5 years. In addition to imprisonment, you may assess a fine not to exceed $10,000, and if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in each verdict. If you do not find beyond a reasonable doubt either the two enhancement allegations to be true, or you have a reasonable doubt thereof, you will so state in your verdicts that you find both the enhancement allegation paragraphs not true. For count 1, you will assess the punishment of the defendant at confinement in the Texas Department of Criminal Justice Institutional Division for life or for any term of not more than 99 years or less than 5 years. For count 2, you will assess the punishment of the defendant at confinement in the Texas Department of Criminal Justice Institutional Division for any term of not more than 20 years or less than 2 years. In addition to imprisonment, you may assess a fine not to exceed $10,000, and if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in each verdict. If you assess a fine, it is not paid to the victim or victims of any, but it is paid into the registry of the court. In this case, evidence has been admitted to you that the defendant may have committed an offense or offenses other than that for which you have convicted him. The court instructs you that you may consider this evidence, if any, in determining what sentence is appropriate in this case at hand, but you may only consider the evidence if you first believe beyond a reasonable doubt that the defendant committed this other offense or offenses. You are instructed that the defendant may testify on his own behalf if he chooses to do so, but if he elects not to do so, that fact cannot be taken by you as a circumstance against him, nor prejudice him in any way. The defendant has elected not to testify in this punishment phase of trial, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it in consideration for any purpose whatsoever. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence introduced at the punishment phase of the trial. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed to fix the same by lot, chance, any system of averages, or any other method than by a full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. The length of time for which a defendant is in prison may be reduced by the award of parole. Under the law applicable in this case, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less. If the defendant is sentenced to a term of less than 4 years, the defendant must serve at least 2 years before the defendant is eligible for parole. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law may be applied to this defendant, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. Suitable forms are attached hereto for your verdicts if you should care to use the same. However, such forms are not intended to influence you in any way in arriving at your verdicts. In any event, your verdicts must be unanimous in writing and signed by your presiding juror. Respectfully submitted, Judge Stephanie Boyd, 187th District Court. State, are you prepared to proceed with closing?
Yes, Your Honor, but we reserve our time for rebuttal.
All right, defense.
Thank you, Your Honor. Good afternoon, ladies and gentlemen of the jury. It's been a long day. Here's the hard part. I mean, he has a record that's evident in the case. Have they proved that record? No. The fingerprints? You tell me how he can compare these fingerprints to any other fingerprints. They're ineligible. That's a tough one for me to say. So I think the fingerprints guy from the sheriff's office gets to use to do this 10,000 times. He just gets up there and says, yep, they're a match. There's no way. There's no ridges. There's nothing in those fingerprint cards that can be compared. Mr. Lopez, I believe, is 41 years old. If you sentence him to prison, keep that in mind that 20 years, he's 61 years. 30 years, he's 71 years. He comes home in a pine box, basically. So we would ask that if, first of all, I don't believe they've established the enhancement allegations. They did a dog and pony show about some kind of 911 call that they weren't able to prove anything on that. And there's no evidence that there was any case file or anything on that case. So we'd ask you to go back and deliberate and think about a fair sentence for Mr. Lopez. If you believe that they proved the enhancement allegations, I don't believe they did. I would say a sentence of about 30 years would be fair. Half of that would be 15 before he's eligible for parole. And that's eligibility. It doesn't mean he's going to get parole. 30 years, he comes out at 71 years old. Thank you.
All right, state.
I'm good for that. Life with or without parole. Ladies and gentlemen, you heard that from that defendant's own mouth. He's telling you what he thinks he deserves. And I'm standing here before you today asking that you sentence him to a life sentence in prison. And I don't do this lightly. However, I want to address the habitual offender enhancement. Now, Mr. Churak just stood before you and said there's no way that the fingerprint examiner, the expert, would be able to compare those fingerprints. That's not the only way that the fingerprint examiner would be able to say that those judgments belong to that defendant. There are many unique identifiers on there, including the defendant's first, middle, and last name, the booking dates, the offenses, all of those things match up. All of those unique identifiers match up. And the state has proven beyond a reasonable doubt that he is a habitual offender under state law. And what does that mean? That means that he's a violent criminal. He wasn't just charged with drug possession or something. He's been charged with 2 violent crimes that involve victims. The first crime is burglary of the habitation. That is forced entry into a home with the intent to commit assault. The second crime is what we're here for today. He's previously committed an aggravated assault. Ladies and gentlemen, this defendant cannot be in our community and act like a civilized human being because he's not. Your verdict changes this community. The defendant is part of the plague of violent crime that has riddled our community. And you have a chance to do something about that today. There is an opportunity for justice to be had today. And justice in this case is that you sentence the defendant to life in prison. I want you to think about the things that this defendant said in his statement. I wish I could have killed him. That's his intent. That's the type of person that he is to his core. Okay, you have an obligation to protect our community and protect the victim. And there is an instruction about parole in there. He would be eligible at halftime. And so even though he may not get it, it's something that you do need to consider. When do you think is a good time for this defendant to re-enter into our community for the third time after a prison sentence? That is what you have to decide. And I submit to you that the appropriate sentence in this case is life. Thank you.
All right, ladies and gentlemen, the deputy will take you back to begin your deliberations. Again, the two alternates, she will place you in a separate room. All right, thank you.